Welcome, everybody, to this keynote session on navigating privacy and security challenges in real-world evidence. As I was saying, as we were preparing for this event, we talked about a lot of innovations happening in the world of RWE and RWD. But as we talk about all this, generally, regulation and compliances are very often either an afterthought or something that we are scared of. However, we thought that if we do this session, this would be our attempt to at least start equipping people with the basics of regulations and data security. Uh, in my past conversations with Kirk, I've learned that this is probably a full conference can be done on this topic, and that might not be enough. But at least in today's session, we thought that we'll talk about current and upcoming privacy and data security regulations which affect RWE, how privacy and regulations are reshaping the collection, use, and sharing of RWE, and then also talk a little bit about balancing the use of data versus privacy and regulatory concerns so that we derive value at the same time be compliant. Uh, Not an expert on this subject, so I won't spend much time on it. Without any further delay, I'd love to introduce the speaker for this session, Kirk Nahra. Kirk is a partner with Wilmer Hill in Washington, D.C., where he is co-chair of the firm's cybersecurity and privacy practice, and also the artificial intelligence practice. He assists companies in a wide range of industries and of all sizes, and analyzing and implementing the requirements of privacy and security laws across US as well as internationally, along with various other emerging legal developments related to AI. He teaches privacy and security law issues at several law schools, including serving as an adjunct professor at Washington College of Law at American University. Kirk received the 2021 Privacy Vanguard Award from the International Association of Privacy Professionals in recognition of his exceptional leadership, knowledge, and creativity in privacy and data protection. He also serves as a mentor to college students, law students, and other young privacy and security professionals with more than a dozen organizations. So thank you so much, Kirk, for taking the time. Over to you to address our audience.
Great. Thank you for having me today. I appreciate the opportunity to be here. I think we're going to load up the slides that I'm using so that we have that. Good. All right. So as was just indicated, what I want to try to do today, I recognize that, there may be some lawyers in the audience, but most of you are not lawyers. So I want to give you a general framework and an understanding of how privacy law works and how it will affect various kinds of information gathering activities, with real world evidence being an example of them, but just give you a sense of how the law works, particularly how the United States legal system in this area works and how it is different from the law in most other countries. And that those differences make some of the activities that we talk about with real world evidence perhaps trickier because you have different legal regimes that you need to think about. So here's what we're going to cover. There's been an enormous amount of change in the healthcare privacy legal structure just in the past couple of years, and that is continuing to change in real time. These developments affect how these laws are enforced, who does enforcement, policy on both privacy and overall healthcare, future legislation, regulation of technology generally in this space. And one thing we'll talk about a little bit later is I am concerned, at least in the United States, that some of the new regulations are actually going to be bad for the overall healthcare system. So we'll think about how that works. There's a lot of moving parts, and that means it is increasingly complicated. And as I alluded to, I think there's an increasing possibility of disruption to effective healthcare as a result of how these laws and regulations are changing. So in order to conduct thoughtful and effective real-world evidence projects, you need to understand this. You need to have a bit, again, you don't need to know all the details necessarily. That's why there are lawyers in this area. But you need to have enough knowledge to frame what you want to do and to understand what's easy, what's hard, what's possible, what may be less possible, and how you need to do these things. So These rules are going to affect how you think about your projects, how you get information, where it can go, what you can do with it, and what the risks are. And again, I don't want to overvalue this, but there are realistic risks here. At the same time, understanding how the structure works can go a long way towards making sure those risks are in fact not substantial and you can still get your projects done. I have a subtitle when I've been giving presentations like this recently, which is why healthcare privacy is a growing mess. I do think it's getting increasingly complicated, and complication in general is not good. I think it just makes everything harder. I say it's complicated and a mess because the law is just changing constantly in this area. One of the impacts of the way the legal structure works in the United States is that there are varying standards for different kinds of entities who have the same information in different contexts. That also may mean there's the different laws for the same entities depending on what you're doing, who you're doing it with, who your colleagues are, who your partners are, who your customers are. There are lots of different laws covering the same information. You know, we're talking about healthcare activities here, healthcare privacy, health information, but there is more and more confusion over what the basic idea of health information even means, why it should be protected more than data about, you know, what you bought at the grocery store or the clothing store, whether that's in fact a good justification for providing additional protections. And there's more and more enforcement, even though the law is not at all clear. And that, again, that just creates confusion, complications, some inconsistencies. So all of this means that the law is just getting more complicated in this area. I don't think the goal of the law is to make it harder to do the kinds of projects that you are trying to do with real world evidence. One of the key areas in thinking about healthcare privacy generally is distinct from some other areas, you know, overall internet privacy, things like that, is that drawing appropriate balances for the healthcare system is actually really hard and really important. There are lots of situations, we'll talk about some of the choices that have been made in the rules so far, where giving consumers more privacy rights than they have today would be bad for the healthcare system, which generally means bad for consumers. And often the law recognizes that, but not always. And so that's where we have to be careful. And again, I think the law, as it is emerging, is creating some real challenges that we need to try to deal with. So my goal, again, is to give you a baseline understanding of the healthcare privacy law in the United States so that you can understand what the rules are, who they apply to, who they don't apply to, what context they regulate, et cetera, so you can do a better job of thinking about your project. So as we walk through this, and really in any kind of project that you'll be doing, this set of questions is not limited to the United States. It's just the answers are different in the United States. You always want to ask, who does the law apply to? That means who is subject to the law? Who's covered by the law? Is it for hospitals? Is it for doctors? Is it for pharma companies? Is it for social media? Is it for, you know, all kinds of questions about who's covered by the law? Then once you know that, you want to think about who the law protects. Who are the people that are being protected? What kinds of people and in what contexts? And then for those people, what information about them is protected? If you have a consumer who's involved in a clinical trial, they may be protected in connection with their medical information that's used in the clinical trial, but that probably doesn't protect their banking information. And so we need to think about, again, what about those people is protected? And then once you have those questions answered, who's covered, who the right people are, I think the most important question is, what are you allowed to do with the information that you have? Are there permissions? Are there prohibitions? Are there restrictions? You know, that's sort of the meat of any privacy rule. You also need to think about what rights the individuals have. If individuals have a right to pull out of a study, for example, or to pull their data out of a study, or to pull out their data out of future uses in future studies, that's important to understand. And then always we're going to think about enforcement risks as well. So let's start with the most important law in the United States on healthcare privacy. Not a new law, but I think some of the history and some of the ways it works are not well understood, and so I want to make sure we have the baseline. The statute in the United States is the Health Insurance Portability and Accountability Act. I highlight on the slides, you can see the bold-faced letters because I want to make sure you all spell HIPAA properly when you use it. Many people misspell it. I can tell you that most of the people who misspell it also don't understand what it means or how it works. And so if you misspell it, it's a little bit of a red flag that you don't know what you're talking about. But the other key point of spelling it right is looking at what the words are. And the P in HIPAA does not stand for privacy. It stands for something called portability. And portability has nothing to do with privacy. Portability has to do with the idea that, again, this is the 1990s, the state of healthcare law has changed in the United States, but back in the 1990s, if you were an employee in the United States, you probably got your health insurance through your employer. And if you wanted to change jobs, it was very hard to get health insurance with your new employer if you had any kind of pre-existing medical condition. So that created essentially an artificial prohibition on people or restriction on people changing jobs. So Congress wanted to fix that. They wanted to deal with allowing people to keep health insurance when they moved to a new job. So they took care of that. They did that. That was fine. But again, that has nothing to do with privacy at this point. They then moved, and keep in mind, this is 1996, so it's the very early days of the internet. They looked at the healthcare system, which at that time was largely a paper-based system. A doctor would fill out a claim on a piece of paper that they had in their office. They would mail it to the health insurance company. The health insurance company had their own paper forms. They would mail it back. Congress said, well, that's not a very efficient system. We have this thing called the internet. We don't really understand it yet, but one of the things we can do is we can say, look, if you're going to do this by computer, and we hope more and more people are going to use this by computer, we're going to come up with standard forms for the computers. And so they built into this law the idea of standard forms for the computer. So if a doctor sends in a claim, it was going to be on a standard electronic form if the doctor sent it in by a computer. But again, that has nothing really to do with privacy or security yet. So it's only at that point that Congress basically said, well, if we're going to have all this stuff be electronic, maybe we need to think about privacy and security, but they didn't know what to do about privacy and security. So, excuse me, if you actually read the HIPAA statute, I'm not encouraging you to do this, there's almost no detail about privacy or security. It just says there needs to be privacy and security. That Congress gave themselves 3 years to write a privacy law. When I teach this subject to my students, I ask them to predict what happened with Congress in those 3 years. I'll just tell you, nothing happened. Congress didn't do anything. So in the law, they told the U.S. Department of Health and Human Services that they had to write a regulation. And so the HHS folks in the United States were told, go write a privacy regulation. We're not telling you anything at all about what should be in the privacy regulation. The only thing we're going to tell you, and this is where all this background gets really important, the only thing we're going to tell you is it's not going to apply to everybody that has health information. It's only going to apply to people that are involved in portability of your health insurance or standard electronic transactions. So as a result of that choice, the way the law was written, HIPAA has never been an overall health information privacy law. It applies to certain information held by certain categories of businesses in certain situations. So it's mainly applicable to doctors, hospitals, pharmacies, I could add, health insurers, and service providers to those health insurers. But that's it. It doesn't apply to lots of other people who have information about people's health. And because there was no substance other than that point, the rules were mainly written by HHS to be policy choices to achieve try to achieve two goals at the same time. One was promoting privacy and security. They obviously wanted to do that. At the same time, they also wanted to make sure they had an effective healthcare system. And so as we walk through these rules, you will see places where they made choices that said, we're going to value the healthcare system over giving more privacy rights. We're going to give good privacy rights, but we're going to give more. If we gave more privacy rights, it would be bad for the healthcare system. So that's the starting point, really important to understand. For example, if you think about doctors, hospitals, and pharmacies, that does not include pharmaceutical manufacturers. They are not subject to the HIPAA rules because they're not involved in portability of health insurance coverage or the standard claims that go in. So that's just an example, obviously important to your industries, about people that have lots of healthcare information but aren't subject to the HIPAA rules. So we have this idea of the healthcare industry coming out of the HIPAA statute, but it's not really what the healthcare industry is in reality, particularly today. So the fact that this law applies to only a limited slice of the healthcare system is important to understand and often creates problems when people inside the system want to work with people outside the system, which is exactly where we're going to be in a lot of real world evidence situations. The other place that we're seeing a lot of impact from that is on the idea of social determinants of health, where we understand today, we probably understood it earlier, just not as well, but we understand today that things like does a person have access to good food or decent housing affects their healthcare status. But we know the way the rules work that the food bank and the housing organization are not part of the HIPAA rules at all. So there's lots of questions about how to share information with them and how that will work. So lots of confusion over what the healthcare industry means. That is confusion both within the larger healthcare ecosystem and certainly a confusion among consumers as well. We also have questions about what health information really means. You have this idea that is true both in the United States and generally around the world that health information is more sensitive than other kinds of information, or at least many kinds of information. And therefore it deserves more protection. But we're going to talk about, like, do we understand what that means at this point, and why in fact does it deserve more protection? So let me give you some examples. I think we would all agree, I expect we would all agree that information about, your mental health or your HIV status or your substance abuse status is sensitive. Okay, that's a category of health information. We know it's not all health information. The HIPAA rules protect your name and address as a patient. If I go to the doctor and I fill out a form saying, here's my name and address, the doctor has that information from me because I'm their patient. That means that information is protected exactly the same way as my HIV, my mental health, my substance abuse information. You could really legitimately ask why that's the case. Why is my name and address protected? But it just is. Then let's take some other information that is clearly health information. I play tennis. I turned my ankle and I need surgery on my ankle as a result of my tennis injury. Nobody really cares about that information. I care about it. My doctor cares about it. Nobody else cares about it. But if LeBron James breaks his ankle playing, pickup basketball on the weekend and will never play again in the NBA, all of a sudden everybody cares about that. But we don't care about it because it's health information. We care about it because it's LeBron James. And so that affects lots of ways we think about it. I don't know why we want to protect foot surgery records, even though it's health information, as much as mental health or HIV information. Then we have things like search history on your computer, medical information. If you look at your search history, you might have a search for, COVID status, or does this mean I have cancer, or, whatever it is. Does that tell you anything about your health? You might be looking for yourself. You might be looking for your friend. You might be curious. You might be writing a paper. You might be doing a research project. I don't know whether that's medical information or whether it's medical information about you. We also have in the United States issues about things like location data. There's a statute in Washington state that says that your location data as identified by your phone is health information if that phone shows you're within 1,750 feet of a healthcare facility. So as I'm talking to you today, my location information is considered health information under that law because the George Washington University Hospital is next door to my office building. Yeah, that doesn't make any sense. So how do we know that that's really health information? We also have research studies. Many of you are probably familiar with these studies that show that things like voting records, purchasing habits, even television watching habits are relevant to certain kinds of medical issues. I don't know how we treat voting records or how we consider voting records as health information. At the same time, there are people in the healthcare industry who want to know your voting status because it's relevant to your healthcare status. So lots of tricky issues with that. Then we get to the substance of the rules themselves. Remember, I said the most important part of any privacy rule is what you can do with information and sort of how consent works with the laws. So the consent rules under the HIPAA regulations are unusual and uncommon, but I think they actually work very well. The purpose is to balance appropriate privacy protections with efficient and effective operation of the healthcare system. When they were writing these rules, there was a recognition that better privacy protection, giving individuals more control over their healthcare information and how it was used, would actually be bad for the healthcare system. So the way consent works in the United States is when you go to the doctor, they hand you a privacy notice, but that privacy notice tells you what they're allowed to do, whether you give your permission or not. And what they're allowed to do is the normal stuff in the healthcare industry. We call it treatment, payment, and healthcare operations. Those are defined words. Treatment, you understand. Payment, you understand. Healthcare operations is basically the administrative activities of running a healthcare business. You're allowed to do that automatically if you're in the healthcare business. If you want to do something that's unusual, then you need to go get permission from the consumers. But this idea was, let's make it easy to do the normal things and harder to do things that aren't very common. So that's the way the system works. The idea is that's good for the system. It gives pretty good protection to consumers. We're not going to give them better protection by letting them control, because if every consumer could control what happened to their information, that would be bad for the healthcare system, which ultimately is bad for patients. So we are seeing concerns about this going forward. We're seeing lots of new developments. I'm not going to get too far down the road on this, just because this is one of the topics that would take a lot longer to deal with. But as we see more and more of these laws coming into effect, lots of other laws that are applicable to healthcare information don't have the same idea about consent, and they're making it harder to use information for legitimate, I would say, appropriate healthcare purposes. Now, one of the other places where they made a choice in the HIPAA rules was in connection with something called de-identification. You're probably familiar with just the concept of that, which is taking information about me and turning it into information that isn't clearly about me or isn't obviously about me. In the rules, HHS came up with an idea because they wanted to encourage people to use de-identified information. They said, look, if you de-identify information such that there's only a low risk that you can re-identify the people, that's okay. That's the standard we want to work. If we made it zero risk, it would be much harder to use the identified information. That would be bad for the healthcare system. But I do want you to think about sort of ethically a little bit how that works. There's one court case. I want to use this one quote that involved, it's an older case. It has nothing to do with the recent Supreme Court action on abortion, but it was an abortion case from the early 2000s. And it involved medical records that had been completely de-identified, so that nobody who was getting the records knew who the patients were. And the court said that even if there were no possibility, zero possibility, that a patient's identity might be learned from a redacted medical record, there would still be an invasion of privacy. And so that's a really interesting point. It's not how the HIPAA rules work at all. But it is something that you should be thinking about as you're designing your projects. It suggests that privacy is not just about the data being identified, but it's about people's sensitivities about their data. So again, just a concept, it's a little different than we think about under the law, but it is something that I want you to consider as you're working through your projects. Another example of the confusion that's coming up. When you go on almost any website today, there are certain things that track what you do on the website. You've probably heard of cookies. There are things called pixels, which are like a cookie, not exactly the same, that track what you do on a website. So if you go to the New York Times, or you go to the Gap, or you go to ESPN, they're going to track what you do on the website. And for the most part, it's designed to make sure that the website's working well and figure out whether people click on this story or that story. They don't care who you are. It doesn't matter who you are, but they know that this computer is doing that. We've seen in the last couple of years some actions from the government regulators that have basically said, if you're a healthcare company, you're a hospital, and you have a website, and you're tracking what people are doing on your website, that implicates the HIPAA privacy rules, and you could be in violation of the HIPAA privacy rules if you're tracking information this way. And so one of the things this did was it just created complete confusion, because hospitals didn't understand that. They didn't think about that. They weren't sure about that. In one of the guidance documents, the government basically said, anytime anybody goes to a hospital website, that is a potential patient, and you have to treat their information as health information. Now, think about the work that you all do. I mean, that's kind of a crazy position. I can tell you, if nothing else, that sometimes people go to a hospital website because they're applying for a job at the hospital. There's no reason to think that person is a potential patient, but that's what the law was saying, and that's how they were looking. So just again, I want to emphasize just the confusion that's going on in this area. We are also having what I mentioned earlier, concerns about social service organizations, and a related question about disclosures in connection with the opioid crisis. There was a belief in the last administration that part of the opioid crisis, part of the cause of the opioid crisis, was that parents and caregivers didn't know enough about opioid patients. So the last administration proposed to make it easier to share information about people that had opioid addiction concerns. And when different stakeholders made comments to the government about this, the comments that came in from parents and caregivers said, please give us more information. If only we had known more, we could have helped our loved ones. And every comment from the patients said, please don't do this. And so that's just an example of directly competing goals. Privacy versus trying to treat opioid addiction differently. And just direct control. And we don't, there's no right or wrong answer to that, but it's a really hard question. So we've given you the background on HIPAA. We know it applies only to certain kinds of entities, hospitals, doctors, health insurers, for the most part. What that means is that what's outside of HIPAA is growing enormously. These are just some examples of where we're seeing this. Websites that gather and distribute healthcare information, personal health records, community support groups, the breast cancer patients of Greater Washington, those exist all over the country for all kinds of diseases. Mobile applications, wearables, health information that Google and Facebook and other entities like that connect. So much of what we consider real world evidence is not part of the HIPAA rules. You're getting it outside of the healthcare system in other contexts, and you want to use it. So you got to think about why that matters. Let me just use a simple example. Many of you probably have an Apple Watch or a Fitbit or something like that. If you go to the Apple store and you buy an Apple Watch, that Apple Watch will collect your steps and your calories, and they're adding all kinds of things that Apple Watch can do about your health. But no doctor told you to do that. No doctor is getting your information. No hospital is getting your information. That means that despite the fact that there's an enormous amount of information on the Apple Watch about your health, none of that is covered by the HIPAA rules. But now let's think about this example. There's reports in the news about Apple partnering with Aetna Health Insurance to have a special model of the Apple Watch that basically is available to Aetna members and has extra things for Aetna members. It has nudges, it has ways to check on claims, it has reminders, it has a variety of things. That one version of the Apple Watch is subject to the HIPAA rules because it's partnering with Aetna. So every other Apple Watch is not subject to HIPAA. This one version of the Apple Watch is subject to HIPAA. So you just get a sense of the confusion there. Now, I'm not worried about Apple's ability to figure this out, but I am worried about the small startup company that wants to try to do this and who says, we've got a great product, and they'll come to me and ask for advice, and I'll say, who are you marketing this to? And they'll say, consumers. Great, if you're marketing it to consumers, you don't have to worry about the HIPAA rules. But I said, what do you want to do if Aetna wants to buy 1 million or the Mayo Clinic wants to buy 1 million? Oh, that would be great. We'd love to. Okay, all of a sudden, if you sell to them, it's a different set of rules. So it's critical to understand that there are different rules in different contexts for the same information. Now, one of the results of this existence of healthcare information outside of the HIPAA rules is that we're starting to see other regulators in the United States get involved in this issue. There's an organization called the Federal Trade Commission, which has general consumer protection authority on lots of topics. It's now getting heavily involved in healthcare cases. They are looking at lots of healthcare cases where there are companies who aren't covered by the HIPAA rules. And in the course of that, they're looking at lots of data, things like location data, where it doesn't really seem like it's healthcare data, but they're trying to turn it into healthcare data. And one of the challenges, and again, this is just something to be aware of. You're not going to, the folks on this call should not know the details of this. You should know enough to reach out to a lawyer on this. They're also making things up as they go along. They're changing the rules. They're making things unlawful in their mind that weren't unlawful yesterday. So that's a major challenge that we are dealing with now. It is clear that they're trying to push the envelope as far as they can on these issues. They are looking for ways to be more aggressive in their cases and in their results. For example, in a couple of cases where entities, some of them being healthcare entities, have collected or used information appropriately in gathering things like, building algorithms and AI, the case that was brought against them said, not only do you have to stop doing this, you have to disgorge all the data, which means you have to destroy the algorithms that you built based on this data. So that's a real issue. That's a real sanction. That's a real concern. And so we're going to watch that. We're going to see how that's developing, but it's a real challenge at this point. We are also seeing them setting out very explicitly their agenda. They are not shy about saying they're trying to push the envelope. They're basically saying, particularly as they start to think about artificial intelligence, they're essentially saying, we missed our chance to do a better job of regulating the internet, and we're not going to miss our chance again. So they are taking some very active steps to broaden out their enforcement authority and to cover a lot of new topics. They have this rule that deals with something called health breaches, which related to security breaches involving personal health records. They're now expanding what it means to be a personal health record. Basically, any mobile app is now a personal health record. They're also saying that if you do something that we don't think is appropriate, we're going to call that a security breach. So that's a real interesting, challenging topic there. On AI, they've gone even further. The chairperson of the FTC has said sensitive personal data, including health data, should be off limits for training artificial intelligence models. Think about that. She says that health data should be off limits for training artificial intelligence models. That is basically a statement that I think says the healthcare industry can't use AI. We've got 100 plus years of data, particularly, again, United States healthcare system. They're saying you can't use that to train AI. I struggle to figure out who that's good for. I struggle to figure out where there are real privacy concerns. There's certainly more privacy concerns than there are in other areas. Not clear that that's good for anybody. Certainly not good for the healthcare system, which means it's not good for patients. But again, lots of challenges there. So we're going to watch that. That's a developing topic as you think about trying to use real world evidence, both on specific projects, but more generally as you're building AI and other kinds of algorithms going forward. So a couple of other things I want to mention just in the remaining time we have. The states are also getting more heavily involved in this in the United States. They are trying to pass new laws. My concern is that these laws are often very targeted and very narrow, but not very thoughtful. And so they're resulting in some situations in ways that are problematic, even though there was an admirable goal in the start. I mentioned a Washington law earlier. This was a law that came out of the Supreme Court's case on Dobbs related to abortion. And it's basically saying you can't use health information, including health data that can lead to inferences about your health, without explicit affirmative consent up front. That's almost impossible to get. So we're looking at this law, and one of the impacts is going to be on things like clinical trials, where they are making it harder to find appropriate patients for clinical trials because you can't use health information, for example, to do targeted advertising online. That's going to have a real problem in general with clinical trials. It's also going to have create a problem as we start to think about things like artificial intelligence, where we know one of the concerns with artificial intelligence is bias. And this law is, if we need, for example, to think, oh, we need to find more minority audiences to make sure our AI is appropriate, a law like this is going to make it harder to find those minority audiences. So again, I'm just concerned about the interplay and how these things are being balanced. There are other laws that relate to the Dobbs statute. There's a law in California that's going to be very challenging. Will have some effect on people's ability to gather information. The law is designed to make it harder for law enforcement out of the state of California to get access to patient information about California patients. So the Alabama police want to check whether the Alabama person went to California to get an abortion. This law is designed to make it harder to do that. But in the course of that, they're basically, the way they're mandating that you do that is to segregate the health, the reproductive rights information from the rest of the information. That means that for millions of women in California, their reproductive rights information, which is defined very broadly, is going to be separated from the rest of the medical records. That's going to be bad as far as I can tell. That's going to create health concerns for all kinds of people because of the concern about a small number of out-of-state patients who had abortion. So again, admirable goal. I don't think they're doing the right balancing. So as we start to look at these state laws and some of the complexity, if you are a California resident even today, your health information is covered by at least 6 different sets of rules. There's HIPAA, there's a state healthcare privacy law, there's the common rule for clinical research, there's a state privacy law. None of those cover nonprofits, and most of those don't cover employer or employee information. So realize that the U.S. approach is very confusing, very burdensome. Compare that to what we have in most other countries. I'll use Europe as an example. Europe has one rule for everybody. It includes health information. Health information is counted as sensitive information, but it's counted as sensitive information in the same way that other categories of information, like whether you are a member in a trade union. So very confusing. You know, I said the HIPAA rules are designed to make the healthcare system work well. GDPR in Europe has none of that nuance to make the healthcare system work well. It protects more information, but whether it does that effectively is a whole different idea. So if you're going to know healthcare privacy law, you need to know all the things on this slide: HIPAA, the state laws, the state general laws, the sensitive condition laws, the specific laws, the medical research, other federal laws, international principles. You need to know all of that in order to do broad-based real-world evidence or other kinds of data collection activities. So lots of emerging challenges, AI in particular, lots of questions about data use, lots of questions about what vendors are allowed to do. You know, they're performing a service for a company. Are they allowed to use that data to build models, to build AI, et cetera? I think we're going to have more and more challenges on how companies are de-identifying data, and more issues about data coming in and out of the HIPAA rules. So you always want to think in any of your projects, what are the rules that are applicable to your situation? There might be more than one. There probably is going to be more than one. Do you need permission? Do you need permission from a patient, from a customer, from a hospital, et cetera? What contracts do you need? What are you allowed to do with the data? What's your business model? What happens if there's a data breach? All of those are going to be important issues for you to be thinking about going forward. At the same time, I'm not sure what we're going to do about this going forward. We have more and more state laws that are being passed, creating more and more complexity. We have continuing tension with the international regime. We're not really sure what healthcare information is or health information is. We're not sure why it gets different protection. And we're not sure whether we're going to have different rules for health information compared to other kinds of information. In the federal debate in the United States, there's the possibility of a federal law. I'm not sure that's going to pass at all, and B, it's not clear that the healthcare problems are going to be dealt with properly. The position of the healthcare industry so far has largely been, we have the HIPAA rules, leave us alone. But that means that in the discussions in the United States Congress about a federal privacy law, the people that know the most about healthcare data, the doctors, hospitals, health insurers, aren't involved in the discussions. Their only view is leave us alone. So I think the national privacy law, if it gets passed, could actually make things worse rather than better on healthcare privacy, just by adding to the confusion. So in general, lots of moving parts on how this is getting regulated, increasing confusion about what health data really means, what health information is, why it should be different, is it different, what's the justification? State law is making this worse. As it stands now, a federal law, even if it passes, will not help. And the big picture issue I want you to think about in particular is whether these rules and complexity for privacy are actually making it more likely that it hurts the healthcare system, that it makes it harder to have an effective, efficient, well-working healthcare system. Again, that's not just good for industry, but that's absolutely good for consumers to have a better, more reliable, less expensive healthcare system. And I am really concerned of whether that's going to happen or not. So with that, I have a couple of minutes to address questions. I'm trying to see how I can do that, but are there particular questions I should be answering, anyone? Increasing scrutiny on data anonymization techniques. How effective are current methodologies in truly protecting patient privacy in the context of real-world evidence, and what new approaches might be necessary? So that's a really important question, and it's driven in large part by the fact that to do real-world evidence, you're usually taking data that is inside of HIPAA and outside of HIPAA. So there are de-identification rules within HIPAA. Those work within HIPAA. There's questions about whether they're truly effective, but we haven't seen real problems with situations where the data has actually been de-identified according to what HIPAA says. But one of the challenges is once you start to connect the dots between that data and data that's outside of the HIPAA rules, all of a sudden it's probably easier to connect the dots and identify a person. So again, we're trying to balance different issues. One of the questions is going to be, if we're doing things like medical research and we can get the researchers to agree not to connect those dots and identify the people, maybe we're not worried if it's possible. But that's a real question. You then have to think about things like security breaches. If somebody steals all this information and they're not going to follow any rules, they can do whatever they want and they can connect all the dots, all of a sudden that's a big problem. But as I alluded to earlier, de-identification is a policy choice because the U.S. government, at least, is of the view that it is good for the healthcare system in general to be able to use de-identified data for more and more purposes. And the harder you make it to de-identify the data, the less able you are to use it for all of those purposes. So there's a direct tension there. They basically said if we make it harder to de-identify, the privacy benefit is very small, but the medical impact is much more significant. And so they've said we don't want to draw the line that way. Again, that's a choice. I'm not sure whether we're going to continue with that, whether we want to have that be the approach. It's definitely a choice. Another question about data ownership and access control and what systems you can put in place to track and audit data access and usage to prevent unauthorized disclosure. That's an enormous challenge in the healthcare system today. We have, I'm involved in a number of security breaches and investigations right now that involve people who had access to information that they weren't supposed to have access to, either because of bad controls or because of a lack of use of the controls that were in place. I do think that companies in the healthcare system need to think about sort of two sides of that. You need to think about access controls on the front end. Who's allowed to access certain information? And in a hospital setting, for example, the access controls are often very limited because they don't want to say to nurses, well, you can only look at the patients that you're assigned to today because tomorrow there might be an emergency and you need to get access to someone's records and you won't be able to. So lots of facilities have very broad access in the first place, but you then need to think about how you're going to monitor on the back end. And so you need to track and you need to audit and you need to evaluate whether people are looking at things they're not supposed to be looking at. So all of that is it's a strategy question about how you're going to deal with the risks that we have related to improper use of information. So with that, I am at the end of my time. I thank you very much for participating. And please let me know if you have questions on any of this stuff going forward.
Thank you. Thank you so much, Kirk, for the enlightening session. This was very informative. And thanks for answering the questions. I can see in the comment box there are a lot more questions, but in interest of time, we'll wrap up currently. Once again, thank you for your time.
All right. Take care. Thanks.